Let's see if something close to that comes up. The next one would be a very broad spectrum question as to what
and you don't expose our ignorance.
No, that's not possible.
That's more important than me. Not more than that. Okay. So the cutoff will rise from 1 to anything up to 1.
So my question was,
this is not a cap.
okay,
This is raising the floor.
Sir, this is only anything.
No, yeah, because he had a very interesting point. What he said was, this thing says that the amount of default of higher value which shall not be more than 1 crore. So is this 1 crore a cap on the total amount that can be taken up? Or is it the floor that can be raised?
No.
That can be raised up to 1. So that's
No,
what I was
can't
saying.
be more than 1.
there was a question in my exam, and that maximum value would be 1 crore, 7 crore, 20 crore.
No cap back. You've got 40,000 crores, also 44,000 crores.
Good afternoon, everyone. It's a privilege to welcome you all on behalf of the Center for Transnational Commercial Law at NLU Delhi to the third session of the symposium on insolvency resolution and cross-border insolvency. Development of best practices is crucial in the initial stages of implementation of the IBC, as it helps in learning from and through the experiences of others while setting a benchmark for performance. All stakeholders, especially the insolvency professionals and lawyers involved in the resolution process, play a significant role in the evolution of the best practices. Hence, the current session will deal with the topic, best practices in insolvency resolution. I would now like to introduce our esteemed panelists on stage. Mr. Sunil Pant, Chief Executive Officer at the Indian Institute of Insolvency Professionals of the Institute of Chartered Accountants of India. Mr. Anuj Jain, partner at BSSR and Affiliates. He is presently engaged as the insolvency professional in the JP Infratech case. Thirdly, Mr. Divyanshu Pandey, partner at J. Sagar and Associates, practicing principally in banking and finance as well as corporate commercial. Fourthly, Mr. Shreyas Jayasimha, founding partner at Arna Law, practicing principally in litigation, arbitration and regulatory investigations. Ms. Varsha Banerjee, associate partner at Dheer & Dheer Associates, specializing in revival of sick companies, securitization and reconstruction issues, recovery of debts and other commercial disputes. And finally, Mr. Aditya Singha, Senior Associate at P&L Offices, practicing in commercial transactions, inbound and outbound investment advisory, corporate compliance, and competition law. Mr. Singha will be moderating this session. Thank you so much.
Thank you. So we would be following a general discussion format where I'll be opening the question up for the panel, and the panel will then come up with their ideas on that particular question. So without taking any further time, the first thing that comes to mind when we talk about best practices is how actually can those best practices be implemented in the real world situations. So the first thing that comes to mind is when we are talking about, and this came across in the earlier sessions, when we are talking about a resolution professional, ensuring that the competing interests of the stakeholders are balanced, how is it that a resolution professional actually implements that balance? And that's a very practical question. So it'll be a good idea to understand from our panelists as to what their views are on this particular point. And I open it up for anyone to start.
See, this is a very, very difficult question, because ultimately what you are expecting is that the resolution professional is able to understand all the aspects of the contribution to be made by each of the stakeholders. In fact, if you really look at defining the stakeholders themselves, there could be some ambiguity in determining the various categories of stakeholders that you have in a resolution process, since this would be different from the normal corporate levels of stakeholders that you would be familiar with. I would actually say that these stakeholders come in about three, if you can say partitions, or three different buckets. One being the primary stakeholders who are actually involved with the resolution process itself, which would include the IRP himself, the COC, maybe to an extent the creditor, the default the corporate defaulter, maybe the other related parties who are actually forming part of this. The secondary stakeholders would be those who are there and who have a predetermined interest in the matter, which would include your workmen and other employees, which would include secured and other unsecured creditors, would include, the government and other agencies to which either dues are payable or which have a certain statutory or a legal role in the matter, or it could also include the shareholders at this point in time. The third would be the extended stakeholders who may not be directly engaged, but who have an important role to play and whose participation in this is going to have a bearing upon how the outcomes finally come out. And this could include the regulator, it could include the adjudicating authorities, and it could include associated markets. By associated markets, I mean areas, for instance, providing insolvency resolution plans, applicants, a market for the applicants where they can come in from, and also interim finance, where there can be a market for interim finance. So these are the stakeholders that I see being there. Now the question is, each of these comes with a conflicting set of principal or core priorities. If you look at the financer, which you are looking at the, let's say, the components, persons comprising the committee of creditors, you are looking at people who are actually looking at recovery. The primary interest there would be recovery of loans, whether in an extended format or in a near-term format, and you would be looking at probably an NPV kind of a calculation to see whether one course of action is better than the other. But the focus would remain how much do I get out of it and whether I can exit this situation easily. The second part of it is going to be in terms of, let us say, the employees. The employees would be looking at saving their benefits and their salaries and seeing how best they can do that. The third part could be the management itself, if you slice it away from the employee component, who would be looking at preserving their status or ensuring that there are no liabilities that come out of this kind of an exercise which would impinge upon them personally. So they would have a certain interest which could be at variance with the interest of keeping this as a high value going concern, or at least retaining or maintaining the value of this as an enterprise. So those kind of conflicts coming in, now the question comes in, how does the RP handle all this? And which is the principal question that has been addressed. The RP has to understand not only the complexity of the operations that he's gone into, he's also got to identify the stakeholders that are there and their possible interests that may be there, so that he can understand at least the nature of interests that are there and the conflicts that could arise in the interplay of those interests. In terms of what are his recourses, the first is the statutory recourse itself. Certain provisions that are built into the code and which are otherwise available to him in a statutory format or legislated format. Now that's one thing that he has recourse to. But the second part of it, which is the much wider part of it, is being able to negotiate solutions which are able to maintain at least a broad adherence to principles of good governance. And that is where, you find that the major issue comes in terms of the skills that an RP has. Now, we had an interaction with RPs and we had an interaction with banks. In fact, I must say I was very thankful to the Indian Banks Association for permitting us to meet bankers and RPs at the same platform. And what we found was that there were a number of questions that came in about these soft skills that are necessary for an RP to be able to push maybe a very good plan across also. Now, if his skills in terms of being able to communicate, in terms of being able to impress upon the creditors about what constitutes a good plan, there would be a gap between what is good, what is desirable, and what is doable. So now that is an issue that keeps on coming up, and therefore, this is an important aspect that the RP has to look at. And therefore, there was a suggestion that when an RP takes over this kind of an assignment, maybe he should be backed by somebody who has these kind of skills, management skills perhaps, backing him up to be able to communicate in a language and in a manner in which these suggestions can be accepted or be understood. That is one part. But on the other side, there were RPs who said that while the RP needs skills, the process of working of the COC itself is slightly opaque. Now, there are decisions that get taken for which there doesn't seem to be an audit trail. So if you want to actually understand why a decision was taken, it becomes difficult to understand the rationale for that discussion, that decision, and what are the conflicts of interest between the members of the COC also. Because please remember, there are different banks, there are different financial institutions, each of whom may have a slightly different take on the entire exercise. So therefore, to be able to understand that also, the RP therefore says there should be some kind of a standardized process which is established maybe under a force of law by IBBI, or it could be by way of governance guidelines that are given to these entities and accepted by banks. So that's an area that maybe we can get some feedback on in terms of how to take this forward. So I think I've taken a lot of time for the initial statement, and I give it back to the moderator.
No, I think I can go next. And being an IP and being in that situation, so I can tell you this is a kind of a class. This is a kind of a classic situation where the recommendation is by an applicant bank, which is a financial creditor in most cases. The appointment is by the NCLT court, and finally the IP is at the mercy of the financial creditors, because ultimately his being in the situation is only there until the COC, he has the COC's vote. The COC at any point in time can decide to replace him or remove him. And COC, as we all know under the law, is primarily financial creditors. So essentially he is there, the IP is there at the mercy of the financial creditors. This is a creditor in control model. All business decisions, all major decisions regarding sale or resolution are done by the financial creditors. Yet the law provides certain safeguards for other stakeholders, i.e. like the operational creditors, or other government agencies. There are certain safeguards inbuilt into the law, like providing a minimum liquidation value or giving them at least a representation on the COC. Further, with the recent amendment, the IBBI has amended the guidelines to say that the resolution plan itself should also mention what are the interests of various stakeholders and how they have been dealt with in the resolution plan. And I think those are the safeguards that have been tried to build in, because eventually, see, the fact is very clear that it is a creditors in control model. I think we can't dispute from the fact that the financial creditors have the final say, because any plan which may be tilted against them may not get their vote for a final approval. Having said that, I think it's the NCLT, the IP, and that's where experience counts. That's where your professional expertise and experience comes in place, where you need to understand what are the different stakeholders, what are their various interest levels. And Sir very well said about 4 or 5 categories of stakeholders, but I'll tell you the primary 2 categories where largely the disputes are, it's the debtors, which includes the shareholders, and it's the creditors, which includes the banks. Primarily, those are the 2 parties, because now their interests are very rarely aligned. So if something is in favor of the creditors, it's normally against the shareholders. If it's favoring the shareholders, it's normally against the creditors. So in that sense, it's the IP's duty that despite being appointed by financial creditors, to at least ensure that everything is done with the concept of equity. There are situations where the COC tries, the financial creditors would try and throw their weight around, would try and tilt a certain decision in their favor. But that's where I feel the IP's experience comes into place, and that's where he needs to wear his fiduciary hat and try and see that all interests are protected. And again, overall, at the end, there is the NCLT which is there to protect the interests, because if there is something which which is quite detrimental to interest of one particular category of stakeholders, the NCLT always has the power to intervene at the final approval of the stage. And I think what a good IP's role should be to, in his recommendation to the NCLT, do highlight the facts where he feels that a particular category of stakeholders is getting shortchanged or is not getting addressed adequately. But I don't think the IP really has the power to ensure that it gets built into the plan, because ultimately the plan is what the creditors would want to look at.
So, very good points made over here, and in addition to that, I would just like to add that it also has to be understood that it is not an antagonistic process. It is a collective process which is not supposed to kind of give a fair deal to all, and that kind of appreciation has to be made and understood by all the stakeholders involved. Like, look, the fact is that a company has been in distress, that is why it has got into the IBC process. Now, Mr. Pant mentioned that there are two primary objectives, recovery and exit. So, from a recovery point of view, it should not purely be seen as a maximizing gains of a particular class of a stakeholder. Even the lenders have to kind of understand that they will not be able to necessarily recover what they had lent to the corporate debtor. So, and at the same time, they also have to understand that it cannot be that the existing promoter's interest or the company's interest or other stakeholders are compromised while taking care of their interest. So, idea should be that it should be a kind of more that wherever possible, interest of all stakeholders should be addressed. And thirdly, clean exit should be given to the parties who necessarily are not able to recover anything. And that kind of understanding has to come in among other stakeholders who rank much lower down the value chain.
If I may, I'm primarily, as you heard, a litigator, and deal with investigations and representing largely victims of fraud and corruption. We have seen the ills that the IBC is trying to set right, particularly in the way the official liquidators had functioned, and almost the informal bidding system that seemed to have set itself in place, and a very pernicious system at that. And this, the ethical responsibilities that now lie on top of the shoulders of the RPs today are at an extremely high level, without the safety net that, for example, a constitutional functionary like a High Court judge would have, with, for example, these duties of neutrality, duties of good faith, of balancing interests, being assured that there will be somebody who is extremely unhappy with any decision or recommendation made by the RP, but without the sufficient, I mean, I would say, and we are in India, we're not in any other part of the world. 95, or I don't know what the exact statistic of companies, are family-owned enterprises. Even in the listed space, yesterday there was a newspaper article to say India has the second highest number of family-owned listed enterprises. So the culture of board meetings taking place at the dining table is quite entrenched in corporate governance and in the functioning of even successful private companies. So the RP's challenge, I would like to speak to the challenge vis-a-vis the shareholders stroke promoters, is I think particularly acute. And we have already seen a spate of resort to unjustified police complaints, FIRs being registered against RPs. We earlier session talked about insurance being available, but that is an inadequate answer. Insurance does not deal with the pain of criminal prosecution. And we all know how easy it is to have a frivolous criminal complaint that is launched against the RP. So I applaud the courage of RPs and of, for example, independent directors, but as a very lily-livered lawyer, I am not registered as either, qualified as either. But I'm a close observer in the space, and I wish to just end by saying that when we are looking at learnings, we should not be, and especially in the early days, we should look to the international experience. For example, Mr. Batra has been extremely involved with Insolvency and several other activities. We have in this room Chris Redmond and others, perhaps from other countries as well. Chris has done 14,000 insolvencies. Is that right, Chris? As a resolution professional. And there would be bodies which are very happy to help. with sharing their expertise and where they have gone right and where they have gone wrong. And I would end by saying, let's not stop at the Anglo-American world and look at the world beyond English-speaking people. And there may be relevant experiences from Brazil, from other parts of Africa, wherever else, few parts of Europe. And like competition law, this is an economic-driven jurisprudence, and we cannot allow ourselves to, the lawyers in us, to get ahead of the basic economic responsibilities that this law seems to cast on people.
Yeah, most of the issues have been adequately covered by whatever all the learned panelists have said. The issue is that when we talk about stakeholders, we primarily identify the creditors. In the IBC also, there are certain proceedings and certain benchmarks which have been laid, and they have said, okay, how a particular class of stakeholder is being treated under the IBC. But the major issue which remains is this only. Since the committee of creditors is driven totally by the financial creditors, probably that sort of the stakeholder of the financial creditor is gaining prominence. Now, what everybody is discussing here, India has a very unique economic environment in the sense that many big houses or enterprises are owned by family entities. So now here the power play is definitely there. How do you balance the need of the stakeholders, of the shareholders, who might not be willing to let go of the enterprises? So here the role of RP is the most important, I personally believe, because the RP has then to see and visualize how all these issues can be streamlined, and then probably a plan or a resolution or maybe liquidation, if it is not a case of resolution ultimately, be put forward which can gain the importance and which can be in line with what the IBC actually envisages. So now there can be one particular issue which I personally feel is there is the issue of interim financing. So the committee of creditors might not be agreeable to that particular thing because they may feel that, okay, further burden is being incurred on the company. The company has to analyze how the earlier debts are being paid off. If a particular asset of the company can be as such sold off to bring in interim finance, why shouldn't that asset be sold to reduce the debts of the creditors? So these are the issues where the resolution professional and all the other members have to come in and take a pragmatic view to ensure that the interest is not only of the financial creditor. There may be other parties, other stakeholders, which, as it was discussed, can be the secondary stakeholders or the shareholders or the government entities or the employees who might be looking in to secure their employment in the company. Because if a company is operating, it will generate revenue, the government will gain, the employees will gain. So all these are issues which have to be looked into, and when we talk of stakeholders, we have to consider these varied aspects other than only a financial creditor.
Thank you. I think there were very thought-provoking concepts and ideas that have flown from the panel, and I think one thing that stuck out primarily, I think it came from Mr. Pant and Mr. Jayasima's statements, that the development of the skills of a resolution professional to identify who are actually the stakeholders who have competing interests, and the skills, the soft skills, which Mr. Pant spoke of, as to how he can present those in a manner in which it doesn't come across that that person is biased. So that skill development and also the knowledge sharing aspect, which Mr. Jayasima said, that is very important for a young economy like ours to ensure that we are not constrained by a particular kind of jurisprudence. We are open to different ideas from different economies where insolvency is quite popular, and how we can ensure that the best practices from those jurisprudence are taken into account into the Indian system. So I think it's a very positive step that Indian jurisprudence is going towards. From that point only, I now wanted to come across to another factor. In the opinion of each of the panelists, what are your views on any lacunae or any shortcomings? Given that this is a new act, there would be certain aspects which are not appropriately addressed. So in your view, what are the shortcomings and how do you think would be the best way to address those? So we need to speak about the solutions as well. So I'll open it up to the entire panel.
Thank you. Oh, do you like to?
No.
All right. See, there are a number of challenges that are there And I think, some of those challenges are also because this is a very new way of handling things. It is enjoined upon the creditors to actually not take a credit-focused view, but to take a revivalist view. And for that, there's a huge mindset change that needs to be there, because creditors up to now have been basically recovery specialists. They've given a loan, and when it has gone bad, there has been a recovery activity immediately. In fact, all the previous, if you look at it in a way, apart from SDR, have been generally focusing on some way or the other of realizing that. And even SDR, to an extent, really looks at finally getting my money out of the way. So with that kind of a situation, the first thing is the code can do nothing about it, because there is a mindset issue that is going to be there. And for that, there can only be some nudges, if we use a word that is commonly now getting into popular parlance. They can only be nudged into taking certain stands, either by way of regulatory push or by way of governance suggestion, where people actually start looking at the entire process and the entire enterprise, not look at the realizable value of that enterprise, but as the going concern enterprise. But that is where, there is a problem that comes in. That while all these factors are established, and theoretically the law also talks about having an enterprise view, who is the person who stands up for that enterprise in the entire process? Even the RP, for that matter, is buffeted by so many contradictory and sometimes conflicting requirements that it may be difficult for him to maintain a sole single stance of being the balancer in the entire process. So the going concern concept actually then again degenerates into a fragmented view of where do I go forward. This is going to take a bit of time so that the going concern concept actually takes root, and all the participants there actually work towards maximizing the enterprise value rather than maximizing their share of the enterprise value. So that's one part of it, and I really wonder whether the Act can do much apart from sort of pushing these entities in that direction. The second part of it that I think is going to be very important is going to be in terms of how do you bring in the remunerations that are available, because that is a very real factor that comes in. For instance, you take the case of a professional who's there, an IP or an RP who's there. If he goes in for a resolution plan, he is paid a certain amount, which is sort of kind of like a monthly payment that he's getting. But if he goes in for a liquidation, he goes in for a bankruptcy, he is getting a flat percentage on the total value that is being set for that. If you really look at it from a very, very, I may say, I don't want to use the word selfish, but if you look at it entirely from a person's point of view and a certain perspective in that, many people would be inclined to sort of see if this can actually go into liquidation, provided there is enough liquidation realizable value at the end of it. That could be one of the things that happens. There is also a question of how do these things get monitored and how should it be done. That's where the Act could possibly step in with supplementaries in terms of regulation or by way of major changes or structures within the Act itself. So these are two areas that I can mention right now. I leave it to the others.
So I think I break it up into two parts. One is the code itself. So I personally feel the code is a very well-written code, given what we studied globally and when the original English law was and how it transpired over the last 30 years and jurisprudence got built in. Ours is a very well-written code. It's not all that bad. Obviously, there are minor tweaks, glitches which are needed. There are some learnings over the last 1 year handling these large cases, which will get addressed in due course. I don't see that as a challenge. There are certain issues like, for example, we did not envisage the class of creditors concept. Today we are in a situation where you may have 99% people of the financial creditors may only have 1.4% of the total vote or 1.5% of the total, which is a real situation which we've seen. And that is the situation. So how do you do your creditor committees? How do you really get any meaningful decision done? How do you the retail lenders or the retail investors are not that sophisticated to take a pragmatic call on balancing everybody's stakeholders' views and making sure the companies are going concern and all the things required under the code. But those I feel will get addressed in a very short period of time. There was a very good concept of liquidation valuation in the code, which was designed to give protection to operational creditors because they did not have a vote. Now the common mindset today with people who want to submit the resolution plan is that the liquidation value is the ceiling. It's actually not the ceiling. It's not even a floor or a ceiling. It's not supposed to be used for your resolution plan. Your resolution plan needs to be independently done based on your assessment of fair valuation and not what the IP's assessment of liquidation valuation is. But those are concepts which are getting misinterpreted, misused, probably because we've not had enough experience. I think as time passes, as experience gains, these things will get addressed, ironed out. So as far as the code is concerned, I don't think there are too many shortcomings in the code. Whatever little there are, they'll get addressed. The other part is on the process itself, understanding of the process. I feel the biggest lacuna is first of all, is the mindset issue, where people don't understand, and stakeholders, part of the process, don't understand what is the insolvency process, at least in the phase 1 when it is a resolution phase, what is really intended and what is behind it. Because the moment you hear insolvency, newspaper headlines scream saying company diwaliya ho gayi. So, which is not really the case, right? It's still a going concern company with assets in there, and all you need is a resolution by getting all the stakeholders together and finding out a resolution. Second, I feel on the process side is, and it was mentioned earlier as well, that a large part of Indian businesses are family owned, which means there is hardly any separation of ownership and management. What we study as management students, that ownership should be separate from management, which is largely not present. So what we now lack is a serious deficit of independent, credible management teams who are there to run the business. Again, a third fallacy is that IP is a manager of the business. The IP is not a manager of the business. He only controls the affairs of the business in a fiduciary role. You can't expect an IP to have excellent knowledge of doing metals and mining and doing textiles. The same person, nobody is that intelligent or experienced. You need people from the sector, you need people who have the experience. So an IP only replaces the board and he takes control of the company in a fiduciary role. He's not the manager. The common fallacy, not just with people, even with the creditors, is that the IP is supposed to run the business in 6 months' time, take business decisions which are in the interests of the business, and if he goes wrong, then he can be prosecuted or pulled up for it, which is again a mindset issue which needs to change. And what we need is strong, independent, credible management teams to support both in the IP phase and also post-IP phase. Because today, a company goes into insolvency, there is a resolution possible, but if you don't know how the business is going to run professionally after the 6-month period, there are good chances that the business will come back into insolvency maybe after a year. So those are things I think we largely need to address. Thirdly, litigation. I think somewhere people who are not happy, it's very easy to engage into frivolous litigation. There's all kind of issues. If the business performance goes down, blame the IP for it. I think those will need to change. The courts will have to take a very clear view on that. So I was speaking to one of our colleagues in London, and he said that English law actually doesn't mention that any acts done in good faith have got protection of the law, whereas our code actually has it written, but it also needs to be practiced. So, and I think that with experience will come and will define whether this is a successful law or it's not.
I had a couple of quick comments as well on this. One, given that it's a family-controlled, family-owned environment, I think what we are seeing is incentivizing the promoters to commit fraud, even if they don't really want to, and giving them some economic justifications for it. Why I say this is, if you see the business model of England and many other island nations, they sell passports, they attract themselves for seeking investments from individuals, primarily to, many of them make no bones about the fact that they are easy places to conceal money. And if now in our system the code lacks any cross-border insolvency provisions, and that's a big gap which has to be, perhaps will soon be filled, there lies therefore compelling economic logic, forget the law, to squirrel away assets outside of India. And then the second other lacuna related to the first is the lack of any provisions to trace or recover assets, and no such powers are given to the RPs. Now, even domestically, there may be attempts to create, for example, now the Benami Act at least is notified, which is a great step forward, but some of those provisions might have to be invoked by the RP and others, and of course the NCLT itself in time. But I think there is the economic incentives are not aligned because of gaps in legislation. And I think that it is not, while we can say it's a great first step, we should take the next steps very quickly. Else we will find many more Vijay Mallyas and a lot more hand-wringing about how money left our country when we know exactly how it's happening. I want to end by saying, if banks don't file DRT or a SARFAESI proceeding, somebody will lose their job for dereliction of duty. But this problem of squirreling away of assets internationally is an international problem. There is a globalized model of how to deal with the products of fraud and corruption in the private side or the public sector side. And there are law firms and accountants in the business of helping people do this. India cannot be blind to this phenomenon. And by not addressing this phenomenon, you are incentivizing it. And so even now, bankers have real remedies in overseas jurisdictions to financially undress the defaulters who committed fraud and corruption, but have not exercised those rights as much as they could have. Now that you have seen some news reports of super yachts being looked at and other assets. But this is not an Indian problem. So I think in terms of policy, framing this problem as an Indian problem is part of the problem. Recognizing this as an international phenomenon that requires us to learn from international best practices is, I think, the way forward.
According to me, well, as Anuj said, that there are certain procedural aspects which will, of course, will get improved. I think the lacuna is not in the code. The lacuna is more in terms of the portrayal of the code. And the way it is being seen as kind of, it will take away all the bad debt problem, it will resolve all the stressed asset situations. No, that's not the case. I think insolvency has to be seen more from a perspective of the fact that, like, okay, if there is any value left, whether that value can be preserved and improved upon. Otherwise, people get an exit out of the business. It's not about a failed business. It's not about, it's like an idea which did not work. So I should be able to kind of exit that investment or kind of like undertaking and move on. So we need to kind of like change the approach in which IBC is being projected. It should not be treated as a debt recovery tool or a debt recovery mechanism. That lacuna has to be fixed. And of course, the lacuna in the implementation from a development of an ecosystem perspective. So as long as, I think perhaps, and this is my personal view, we have got a fantastic law, but perhaps there was required to be a little bit more preparatory work and more education about the law before the implementation of the law in terms of getting into it to implement it to improve our business rankings.
I'll take it forward from what was just said, is that it's all about the perspective. We need to see, we need to evaluate what is the code and how the code can solve problems or solve the issues. So for that, definitely there is a requirement of gearing the entire ecosystem, in the sense all the parties who are coming in the forefront because of the IBC, whether it's the company, whether it's the stakeholders, whether it's the lenders, financial creditors, they have to come together and they have to see what is the ultimate purpose being achieved. Maybe a company is perfectly capable of reviving, doing work, whatever it may be, but still some minor creditor or some operational creditor can take that company to IBC, because there is this requirement under the IBC, which is a strict, simple statutory requirement, which once met can trigger the IBC process. So here we need to evaluate, understand and see what is it that we are ultimately looking into, how this code can give benefit to the economy as a whole and how it can take us forward. When we talk about shortcomings, code in the last 1 year has done a very good job. We have seen a lot of progress. Something more will come out over the period of time. But I personally feel there is some lacunae as to the second stage, what Mr. Anuj was saying, which is monitoring. How do we monitor the process after an IP has been appointed, after the IP takes over the company, and he starts with the second stage, which is the resolution of the company. Even after the resolution of the company, and assuming a plan is sanctioned in case of a company, how will that plan be subsequently monitored? The IBC and the regulation says that, okay, the plan itself has to provide for the monitoring of the scheme. whichever is approved by the adjudicating authority. But then we have to see what's the recourse, assuming somebody is not implementing it in so many words. Regulation in one point only say that, okay, probably the management who comes into the picture after the plan has been approved can approach the NCLT and say that, okay, this is the thing. And a consequence of non-implementation is liquidation. But what sort of an affirmative actions can be taken to ensure its due implementation, the strict adherence to the provisions of the resolution plan, and then ensuring the continuity of the operations of the business, which probably the plan envisages, is something which has to be seen, and over the years, with time, with experience, probably we'll realize and we'll work forward in synergy so that all these things can be balanced.
Thank you, Ms. Banerjee. At this point, just like to open it up to the audience if they have any thoughts on these 2 points that have been discussed. Just one.
The IBC code talks about the duties of the board of directors which get suspended. I mean the powers which get suspended. What about the duties of the board? There is a tremendous confusion in the industry. Some feel that the board should continue to function and that they should discharge their duties. Others feel that no, now the IP is in the helm of the affairs and the IP should drive the... I mean in terms of the company law compliances, especially with regard to, say, the accounts finalization, the conduct of AGM and stuff like that.
Sir, would you like to direct that question to a particular panelist?
Anyone can answer it, please.
Sure. So, well, in my understanding, it will be the IP who will be discharging those functions because the board's powers are suspended. Like they are not, the board exists, it's not dissolved, but at the same time, the powers and functions of the board are going to be exercised by the IP, acting in name of the board, because he eventually is kind of like has taken control over their authority.
I'd like to have the comments of Mr. Jain.
If I can just quickly add to Divyanshu's answer as well. Just now, Anuj also mentioned the variety of industries, the complexity of industries of the company and their enterprises. Surely, the IP, the question, if I may interpret it slightly differently, is there a continuing fiduciary duty on directors, even though when they are in suspended animation,
Sure.
to guide and to properly inform the IP? As for example, if the compliance manual that is maintained by the board is inadequate or it is missing entirely, can then the IP be held? To what extent can the IP be held liable for non-compliances? And so there may be some continuing obligations of the board, which as courts might flesh out from case to case, which might not mean signing off per se, but certainly keeping the ecosystem of compliance data live and updated. Perhaps.
Absolutely, and I think the question gets compounded in case of a company which is listed. So in terms of, apart from company law, the SEBI compliances, since Mr. Jain has been through that, I would ask him to please share the experience.
No, so I'll tell you, my own view is that obviously there cannot be two power centers. So during the CIP process, you cannot have a board making a decision and an IP making a decision and both of them fighting in court on that same decision. I think that is fairly clear. In terms of and I'm not really aware of any powers or any actions which independent directors of the board make. See, if you're an executive director or you're an executive of the company, you still do functions in your executive capacity. Maybe not as board of directors, but if you're a president of the company or a CEO of the company, it doesn't mean the CEO automatically gets stayed. So in your executive capacities, you still continue to do what your duties or what your responsibilities are, i.e. in terms of doing the compliances, filings, doing whatever required to run the business to run it as a going concern. But in terms of the board, the powers of the board, as we understand, as we interpret it, is obviously the powers vest in the IP, and it's only for a temporary period. It's in a fiduciary role. So whatever the board is supposed to do, the IP, all those powers come into the IP. So things like opening a bank account, closing a bank account, doing stock exchange filings, or even doing quarterly filings. Obviously, there are different views. It's still getting developed. But as things stand today, I think the responsibility or powers of the board vest in that IP. Obviously, if there is a non-compliance or there is a serious issue from the past, the IP cannot be held responsible for it. He's there only for a temporary period and he's in a fiduciary role. He's come in, so he can't be expected to take over all the ills or wrongdoings of the past. But during his period, I think it is the IP's responsibility to ensure that things are getting done.
Sure, but let me ask you then the question slightly differently. Say, with regard to the accounts finalization for FY17, is the IP competent enough to be able to say the accounts, the whole thing about the accounts, it should be recommended by the audit committee, it should then be approved by the board, then cleared by the shareholders. So how can the IP step into the shoes of such a complex, the company law driven process?
That, very honestly, is something that, it will get tested. Until now, see, the board also doesn't get into the account. As far as I have seen, the board also relies on what the auditors have done, relies on what the CFO of the company tells them to do. At least I have not come across that situation where the board gets into the accounts or the numbers. They also rely and they have their checks and balances. I think the same level of diligence the IP also needs to maintain. And if it takes time, you can obviously seek extension from those timelines, extension from filing financials, but I don't think the IP can walk away from the responsibility of signing. Obviously, the accounts will mention that it is for a period prior to his coming onto the business, for a period where business was controlled, managed. It will have all the necessary statements so that anybody who reads those accounts understands how they are drawn up and in what capacity they are being signed.
Thank you.
Can I just make a point? This point has been discussed enough, but I wanted to make a very different point. And I think this panel has made some very relevant and also some very excellent points. But I just wanted to make one observation, which I also mentioned in the presence of the minister yesterday, the PhD's annual convocation. We all know that there are certain flaws in the law, but none of them are fatal. And they are being addressed. The best part is that the government is mindful, is open to consider, and we probably see amendments very soon. As far as the law is concerned, regulations, any which ways we've seen amendments, we've seen clarifications coming in very well. What actually bothers me is a slightly different point, and that's something which I take from what Sunil, you mentioned about the mindset. You see, we have to realize that we've gone from a debtor in possession law to the creditor in control regime, walking in, or rather, taking a leap of faith from one end of the spectrum to the other, without giving the stakeholders adequate time to comprehend it, without educating the society or the players, including the consumers, advisors, to understand how to respond to this. That transition didn't really happen. Now, one of the risks, and that is the caution I want to apply to myself, when we start thinking of what this law is meant to be, is that, I've seen that a trend, which I hope and pray doesn't really develop further, is that this law is beginning to be used as a tool to hammer the debtors. An insolvency law is not meant to brand every debtor as dishonest. In business terms, you succeed, you fail. Unless as a society we recognize that failure can also be legitimate. It's not just that only success is legitimate. We would never have the temperament to deal with the insolvency. What United States did when they introduced Chapter 11 was that collectively as a judiciary, as a society, as an economy, they recognized that businesses do fail, and you have to, as a society, as an economy, learn to forgive unfortunate debtors. That's what the Supreme Court judgment in 1981 of the US, one of the Supreme Court judges said. And once you learn to forgive, then you give a second chance. If you will not forgive, you will not give a second chance. And that means that you're striking at the root of entrepreneurship. And if you start demoralizing the businessman, then that is also not good. So at some point in time, we have to realize that we have to demarcate that those who have been dishonest, yes, penalize them. But those who have failed for legitimate external business factors or other factors, we need to sort of give them a second opportunity and not just start branding them as dishonest in the society and create a stigma around it. And that will defeat the legitimatization of the insolvency law. It is not to be seen in negative connotation. It should not create negative aspects for any stakeholder. And I think that is what we really need to think from a philosophical point of view as to how we need to control our responses and reactions to the insolvency law. Because if we just end up getting to the other extreme, it may be very difficult to restore the confidence of one set of stakeholder, which is a very key stakeholder, that is the promoter. They are the ones who create businesses. Lenders don't create business. Lenders obviously give money and they're entitled to protect their interests, but they don't go out and take risks, isn't it? They're the ones. So we just need to balance it at some point in time, even though it is a credit and control regime, and have those checks and balances. That's where the RP plays a very important role by making sure that all the players are around the table, they have a say, nobody feels marginalized, nobody feels excluded. But of course, you still play by the rules of the game. Just wanted to make this point. Thank you.
Just one question to Mr. Jain and Mr. Pandey. See, the occupier of the factory, under the Factories Act, has to be a director. And that person has been identified, it has been reported to the Chief Inspector of Factories. I think there is no change in that. So those duties of the directors will remain.
Excuse me.
I want to add some point here with respect to the balancing of interest of the Insolvency Code. This code rights substantially act on the unquestionably word of the creditors. They are overlooking the rights and the interests of the debtors everywhere. They do not have the liberty and they do not have the choice to present themselves. Even they are ignoring the basic purpose of the natural justice here. My only question is, the moment Section 8 petition is filed, insolvency proceedings get initiated. The debtor do not even have right to rebut the insolvency proceedings with regard to that. So I just wanted to note how this kind of interest can be balanced with respect to the debtors also.
If I may answer, I don't think it's like that the debtor does not have a right even to appear or make his submission, or either it's even in Section 7 petition or even in a Section 9 petition, they are always heard. The idea of IBC is that if there is a default, yes, you need to identify it. And that default can be a genuine default, as was discussed right away, that it can be a situation of business failure, of any change in the economy, any such things which may be outside the control of the promoter. But the idea is identify the default at the inception so that it can be rectified. It's not like that any vested right of the promoter group or the debtor is being taken away right away. They definitely have the right. They can themselves be the resolution applicant. They can work with their creditors. They can come up with a scheme. So the right is there. But yes, the identification is what is one of the basic pillars of IBC. So therefore, that is being addressed.
General practice which has been followed by NCLT and NCLAT, the moment Section 8 notice had been given to the person, insolvency proceedings get initiated.
You reply
Here,
to Section 8 notice.
If in case I don't reply, at least there should be one opportunity to rebut.
Even at Section 9 stage, which is filed before the NCLT, the corporate debtors, even the Honorable Supreme Court has held that there is a right of natural justice. They are heard. And in every matter, a notice is being issued by all the NCLTs. And it is only after notice, if the CD does not appear, then yes, they will not wait for infinity for the CD to come and say, okay, this ABC reason. They are given reasonable time. In practice, all the NCLTs are doing it, NCLAT is doing it. So that balancing of interest, in my personal understanding, is there. You are given an opportunity.
And at times there are more than one hearings,
Yeah,
there are more than the multiple hearings, and generally I think the precedence has been that corporate debtors have represented for challenging the admission or supporting it.
This concept of natural justice has been
Well built in the early days of the code.
Thank you. One last question, if we have any. Yes, please.
My question is to Kansa. Sir, you talked about stakeholders, sir, and you clearly specified that the corporate stakeholders are different from what stands in IBC. So in this equation of the entire what IBC has built, where do employees stand? Apart from them being secondary creditors, where do they stand? We promised something in directive principles, employees' participation in the management of the company. I think they're equally important when it comes to the insolvency, a resolution process. We have seen Unilever case where court promised something to the employees, recognize their rights. Have we gone back, or was it an apt opportunity lost by legislature where they could have actually identified one of the stakeholders who's still an ethical question more than a legal question, whose rights are more of an ethical question than a legal question, sir?
See, the first thing I would like to make very clear is that this distinction that has been made is entirely mine. I've done it only to be able to better understand what kind of stakeholders are there. I don't think it is enshrined in any act, code, or regulation. That's part one. The second part is that, yes, worker rights are there. And if you look at the cascade, the waterfall system, workers' rights are enshrined in terms of the payment to the workers once a resolution is, when you started the realization of the assets. So that is there. It is all built in. And there are different. No, there. If you look at it, it says workers who have not been paid for about, 1 year.
Workmen for 24 months.
Workmen for 24 months and others for 12 months. They are already there in that waterfall that if you look at it in terms of their priorities of being paid off. So that's there. So I don't think they've been overlooked. All I'll say is it has become more structured because earlier there was a view that workmen dues will predominate. They used to come before commercial dues. Here there has been an attempt to balance commercial dues also, because if you really look at it in terms of equity also, commercial dues are generated out of public funds. It's your money. So therefore, that also has to be given a necessary priority. In fact, the government has got relegated. The earlier principle used to be that sovereign dues will prevail over commercial dues. But now that has got amended to that extent. So I think, it's an attempt. I mean, as everybody said, this is an evolving situation and it's an evolving legislation. It's a live legislation. It's not a dead legislation. So you'll see maybe more changes coming in. I hope they'll all be for the good. Thank you.
Mr. Anuj, what is your experience about the timeline? Timeline as mentioned in the code. Do you think that it is applicable to all type of the companies in all type of the situations to have a resolution plan in place and achieve everything? Because you are facing a timeline issues also.
No, so I'll tell you, see, in any law, in any procedure, there will always be exceptions. Correct. So exceptions cannot be the norm. Correct. But by far, generally speaking, if you see the larger part of corporate India, the kind of businesses there are, my own sense is these timelines are manageable. 6 to 9 months is a very good time to agree a plan, to get all parties on the table and agree a binding plan. The scheme does not need to be implemented in 9 months or 6 months. The plan needs to be agreed. The implementation, depending upon the complexity of the business, can span over multiple years. I think we need to understand very clearly what the code requires. The code requires that everybody unanimously agrees to something and then it becomes binding on everybody. And that, for that 6 to 9 months, I think is a fairly decent time. Maybe in certain exceptions where there are reasons or force majeure reasons or some other reasons, timelines need to be extended. I'm sure the courts will take a pragmatic view there. But I don't think we can develop a law based on the exceptions.
Thank you so much, Mr. Chen, and thank you for the enlightening questions and the responses. I think that there are a lot of takeaways from this particular panel discussions, primarily pertaining to the role of the resolution professional, and that's, I think, the theme of the entire symposium as to how a resolution professional can actually ensure that the entire process happens in an effective and a judicious manner. So thank you so much to the panel, and obviously if anyone has any questions, we can address them. We'll address them after the panel. I have a query,
just one. Whether NBFCs are included here or excluded? I just wanted to know this.
No, they're not included. The law doesn't include financial services companies.
But financial services providers and NBFCs are two different things. They have given a specific list. I'm like, sorry, maybe I'm offended.
I thought financial services.
I'm sorry,
the definition is very broad of financial products, so quite a few entities could get covered. You don't necessarily have to be NBFC.
Thank you.
Thank you.
This session has come to an end. I request please be seated, and we have some mementos for you. The session has come to an end.
We'll just start within 5 minutes. Right? We'll just start within 5 minutes.
Use it for the presentation. And just for my own. For my own notes. Sure.
Yes, I know. Yes. He already got those.
Kindly be seated. A very cordial greeting to all. Now we are going to start with our fourth session on cross-border insolvency. This session will try to evaluate the advantages and disadvantages of the existing regime on cross-border insolvency in India, along with discussing the viability of the adoption of unilateral model law, especially in the context of insolvency of enterprise groups. I take the opportunity to introduce to you our speakers for the session. We are delighted to have Ms. Jenny Clift as speaker for this session. Ms. Jenny Clift is a senior legal officer with the International Trade Law Division, United Nations Office of Legal Affairs. Our second speaker is Christopher Redmond. Mr. Redmond is a partner with the Financial Services and Capital Market team at Hush Blackwell. We welcome you, sir. Our next speaker is Mr. Sumant Batra. Mr. Batra is the managing partner of Kesar Das B and Associates and heads its insolvency and secure transaction practice. We welcome you, sir. Our next speaker is Dr. Risham Garg. Dr. Risham Garg is the director of the Center for Transactional Commercial Law at NLU Delhi. We welcome you, sir. Next we have Mr. Dhananjay Kumar. Mr. Kumar is a partner of Cyril Amarchand Mangaldas, and he will be moderating the session.
Thank you very much. I'm very happy to have a very distinguished panel here with wealth of experience in cross-border insolvency and related matters. What we are going to do is sort of introduce the topic, and then we will sort of talk about what Ansitral is doing recently, and Jenny Clift will come in will have some useful insights into it. We will also look at what kind of model India is looking to follow while adopting the Ansitral model law. And we can talk about some of the challenges, and we can also talk about what are the recent developments. I think through the day we have talked about the need to have a cross-border insolvency regime in India. Our cross-border insolvency regime is very limited. It has not developed, and we have not, despite having provisions in the IBC to have bilateral treaties with different states. No bilateral treaties have been signed till now, or there has not been historically a regime for cross-border insolvency in any case. That achieves particular the need to have a cross-border insolvency regime achieves particular significance. And if you look at what has happened in past, say, 2 decades, many Indian companies have gone ahead, invested outside. Similarly, lots of foreign direct investment has come into India. And there is definitely a complete interlocking of Indian entities with foreign entities and vice versa. But just to sort of just before we introduce the sort of model law and how that works, if I could ask Mr. Garg to just make a quick comment on as to what are the tools for cross-border insolvency internationally, and what are the sort of advantages and disadvantages, if you could make a quick comment on that.
Thank you, Dhananjay, for the opportunity and the topic. So the question or the point that has been raised is what are the various tools for dealing with cross-border insolvency cases and what is the optimal solution for India. So I'm primarily not a practitioner, I am primarily academic. I will like to focus upon the aspect which is more in consonance with the legislative practice and the law. So I could start by rephrasing it by, instead of using various tools for cross-border insolvency cases, we could use that there is cross-border insolvency and what are the main issues, in the sense that what is needed by the debtor and what is needed by the creditor. So certainly certain reliefs are required. What is required by the party seeking a relief, who comes for relief? So first thing is, if there is a cross-border proceeding going on, that is in some other country, and it may be the creditor, assuming it is the creditor comes to India, first thing they would want is that whether the foreign proceedings will be recognized in India. Then another aspect is that they might want to file insolvency proceeding in India. Another aspect is the foreign creditor might want to participate in existing insolvency proceeding going in India. And then certainly the issues of where and when the assets may be realized. Parallel topic is the location of assets. So the location of assets might be in one country, the regime, the legal regime, and in which we call generally is either considered to be a universalist regime or a territorialist regime in simple terms. This means if India adopts a legal regime which is more territorialist in nature, which means that we will give preference to our creditors and only then we will recognize the foreign creditors. But then the problem is, if assets of the debtor are located outside India, so as we have seen in a lot of high profile cases, then what do? There is a problem. And another aspect is the universalist regime, which is a insolvency proceeding, and it is just an insolvency proceeding whether it is in US or India or UK or Singapore, and all the parties, creditors, debtors shall be considered there is one insolvency proceeding, and we need a cooperation between the courts and the participants. So what is required is certainly there needs to be a cooperation. Now, to get this relief, we are required to frame a law, or we are required to frame certain regulations. Now, everybody knows that there is some use of transplanting of laws. Legal regime in UK is there, a legal regime in US is there, it is working, legal regime in Singapore is there. We feel that yes, it's working. So it's good model and we should adopt, and we could adopt in India. But the situation in India is vastly different. So there are dangers. There are certainly inherent dangers in adopting that. And assuming there is a argument in India against adopting a universalist regime and in favor of a territorialist regime, or let's say taking the help of protocols, case by case protocols. But in India, we have a lot of experts here, they would know better, but my perspective of an academic is that because of the innumerable possible number of cases, the protocols might not be feasible, because you require individual cases, individual protocols, and that certainly is of a practical hazard. So one option is the model law. Model law, again, I would want to distinguish it with other tools of legislative tools. that is a treaty form. We had example in arbitration law. Arbitration Act is modeled upon the model law on international commercial arbitration, but we have adopted the New York Convention, which is a treaty. So in arbitration in India, we have adopted the two techniques. One technique is of a model law in adopting the Arbitration Act. Another is of the treaty by adopting the New York Convention in 1961. So model law has some inherent benefits. We can make a law. If assuming tomorrow or in the some time later, UNCITRAL prepares a treaty on insolvency, then we don't have option to make our law. So I think that sums my discussion.
Well, Mr. Redmond, we have talked about there are assets outside India of Indian companies. And if we have a cross-border regime, how do Indian creditors benefit if we take the proceedings outside?
Thank you. First of all, it's a pleasure to be here and an honor, so I appreciate being able to participate in this symposium. Let's go back about 30 years and talk about how this whole process developed. 30 years ago, if a company had cross-border operations, say in 5 countries, and the company became insolvent, then there was an insolvency proceeding filed in each country, and in each country, the creditors in that country received what was in that country, and that was it. And so what this did is it created a very substantial amount of expense, and the creditors would be siloed as to the assets in their own country. And so because of more and more companies operating on a cross-border basis, because of more insolvency proceedings occurring, the attitude, the concept changed. And the concept became that these should be collective proceedings, that the debtors' assets and liabilities should be treated on a whole. So let's take an example that India was one of the locations this company was operating in, but that company ceased operations in India and left and went to operate in another country. You had a lot of creditors here. Under the old concept, if an insolvency proceeding was filed here, you'd have very little or no recovery for creditors. That'd get zero because there's no remaining assets. Now, on a collectability issue, when you take all the assets in the different jurisdictions and you spread those, then creditors receive some benefit for the totality of the assets. You have simplified insolvency proceedings, so the cost and expense is much less in the process. And where Indian creditors can be affected is if the main proceeding is in another jurisdiction, but there were creditors in India that received preferences. It may be that the former principal, is in India, and he received several $1 million that he took improperly. And so it's necessary to have the insolvency representative from the other jurisdiction come to India, be recognized, be able to bring actions for preferences so that all creditors can be treated equally, and to bring actions against the principal to again, retain that money and bring it back so that creditors can be treated on an equal basis. And part of the issue is that it's extremely important to have a well-defined law that sets that procedure out in a very definitive fashion so that it saves time and expense and there's predictability.
Would you like to touch on that? Why is this the missing piece for the IBC?
Well, of course, we've spoken about this academically, theoretically in the past, because we've been sort of trying to create a case for the adoption of the unsettled model law almost for about 7-8 years now. But having now experienced live firsthand as to what the cross-border issues are under the new insolvency law, where almost all the big enterprises that are in insolvency at the moment, in particular those 12, the infamous or the famous 12, most of them have cross-border issues. And some of them have very complex cross-border issues. I mean, at least one of the cases that I'm involved in, you have at least 30 to 32 enterprises abroad, out of which at least 12 are in insolvency, including those that are in receivership or administrationship or different kind of insolvency proceedings in different parts of the world. And we're talking from Australia to Singapore to Thailand to Germany to Italy to London. And in spite of the fact that businesses have been sold, monies are lying, we're not able to claw them back. Now, obviously, we are in touch with administrators or receivers and using our good offices to the extent that we can to sort of get information in the first place and then try to see how that information can be utilized to sort of take the further steps, including to sort of get some money back. But so far, unsuccessfully. And it's not surprising because this is something which we had anticipated much earlier, even before while the law was being proposed, that this has to be dealt with as an integral part of the code. The code is incomplete without it, and that is why the Joint Parliamentary Committee, in very harsh and strong terms, expressed their displeasure when they said, where is the cross-border insolvency law? And that is why today, at least we have the basis to go back to the government and say that we need to do this. So the point that I'm trying to make is that the challenges that we are facing today in the absence of the insolvency law, the cross-border insolvency law, is that we do not have a tool to access the foreign jurisdiction. We do not have a mechanism where we can seek recognition of the Indian proceedings in foreign courts or by foreign courts. Third, we do not have a mechanism by which we can seek relief in those courts in respect to the assets that could directly or indirectly form part of the Indian insolvency or insolvent estate, and therefore that needs to be protected or clawed back, or at least to the extent that its value is protected and not diluted. And the fourth is, of course, to create some kind of a mechanism for cooperation between the Indian court and the foreign court, and also the office holders in both the countries or in multiple jurisdictions, as the case may be, in order to ensure that both, while preserving the sanctity of their national proceedings, are yet able to complement one another in getting the maximum returns for their respective stakeholders, without, of course, diluting the respective provisions in their respective countries. So that today is a non-starter. I mean, the problem is that in the absence of a statutory framework, we just do not have the tools, techniques, means, ability to just take any step whatsoever. And if we were to invoke the common law proceedings, it takes years together to file proceedings, get recognitions of the orders of the court, get recognition of the authority of the insolvency practitioner, the office holder, and then to convince that this was an order which was passed in justifiable circumstances, and to establish the contractual relationships, and to demonstrate that the order really that is being sought is justified. All that exercise will take months. The cost is going to be phenomenal, and the results are going to be unpredictable and uncertain. While in a cross-border insolvency, the best advantage is that if the two countries have adopted the model law, then we know what the path ahead is and what reliefs you would get, what you would not get, because it's a part of the statute. So that's the advantage that we're missing, and that advantage, in fact, is turning out to be a very big that missing advantage is turning out to be a very big disadvantage already, and that is why the bill has already, a draft bill for the cross-border law insolvency based on the asset model has already been presented to the government, and we're hoping that in the next few months we would see it in the shape of a legislation.
Thank you. Ms. Jenny Clift, we heard what are the problems. We heard Mr. Redmond, we heard Mr. Garg, we heard Mr. Batra as well. Why is model law the perfect answer for all of this, the problems that we are talking about? No, to you.
Sorry, well, I would have to say that it is the perfect tool because it's a tool negotiated by UNCITRAL. But I think it's a very good tool. I won't say it's perfect. There are issues that it doesn't cover. But I think experience with the use of it in the years since 1997 have shown it to be a particularly effective tool for achieving recognition of foreign proceedings. ordering relief to assist foreign proceedings, and fostering coordination and cooperation between proceedings. So it's now been enacted by some 43 states, and I think this morning I was running through the countries that are currently considering enactment, and that's another 7. So I would imagine in the next 12 months or so we might add another 7 to the 43. So I think it's starting to gather it's like one of those rolling things that get bigger as they roll. And I think that the reason for that is that a lot of countries have done their domestic insolvency law reform, and they're now starting to see the need for cross-border, and they've got cases. And so when they've got cases and they look at what tools they have in the toolbox and they realise that they don't really have anything, they then, the model law is really the only alternative, unless you proceed on a bilateral basis, and that's not a desirable.
Efficient and
it's not efficient. It's too costly and it takes forever.
But just to add to what Mr. Batra was saying, it's not as if we need to adopt the model law today to seek recognition. Let's say in the US, we have had a case where our SICA proceedings have been recognized under Chapter 15. So, Mr. Redmond, do you think the way the IBC is structured, can the RP seek this recognition as things stand? Let's talk about the US if that's the most closest for you.
Yep. The answer is yes. I think I've actually reviewed the Insolvency Code, and it's well drafted, and I think there's provisions clearly that the insolvency professional could be qualified as a foreign representative. I want to add to what Sumant and Jenny have related, and I just want to give you 2 brief examples. I've been a bankruptcy trustee since 1978, and many of those cases that I've had cross-border cases, so I've had to go to other jurisdictions to get recognized. And obviously I'm dating myself, but a number of those were prior to the time the model law was even thought about. And in those cases, specifically in one case I went to the Isle of Man, I went to Switzerland, I went to the Caymans, I went to Netherlands Antilles. Huge fraud case, because cross-border cases come into 2 areas. One is you have the honest debtor that has operations in the overseas jurisdictions you want to coordinate, and the other is fraud. It's where you have people divert funds. They transfer funds overseas. They're trying to secrete funds away from creditors as part of the process. First case was a $180 million fraud scheme in which funds were transferred to many jurisdictions. I filed applications. I ended up getting recognized. I ended up bringing actions for recovery. And the bottom line of all that was it took a lot of time. It took 3 years. It was very expensive, and it was very frustrating as part of the process. And the most important thing was the ultimate cost and expense reduced what creditors received, because you had to go after, get the money back, and there was substantial diminution in what should have been able to be paid to unsecured creditors. I want to fast forward you then to after the Insolvency Commission approved the model law in 1997. The U.S. and the U.K. both adopted the Insolvency model law after a certain period of time. We had a case where there were 2 doctors from India that went to London and practiced there for a while, and then came to the United States, came to Georgia. The 2 doctors got involved in a number of real estate projects, and as many doctors do, ended up, the projects failed, and they had to be foreclosed, and there was a deficiency. The doctors owed about $3 to $4 million. The bank called and said, can you do some searching to find out if there's assets in overseas jurisdictions? And so I did, and I found a house they had in London that was worth about $1.2 million. And we were going to get charging orders to go after that house when these 2 individuals filed bankruptcy in Georgia. There was a trustee, bankruptcy trustee appointed. We went, as we were required to, we went to that trustee, disclosed there were assets in the UK that had not been listed on the bankruptcy schedules. The U.S. trustee got authority to proceed to file an action in the High Court in London, and we were retained to handle those proceedings. So, in the application in the High Court, we filed an application to have the U.S. trustee recognized as a foreign representative. We, as part of that same application, requested that the UK court determine that COMI, the center of main interest, was the United States. We also asked that the court determine that the real property in London was an asset of the bankruptcy estate in the U.S. We asked that the property, that the foreign representative be allowed to sell that property. We asked that the foreign representative, the U.S. trustee, be put on the property rolls as the owner of the property, and that once the property is sold, that the proceeds be paid back to the United States so that trustee could make a distribution to creditors. Now, contrasting the case I talked about earlier that took 3 years to go through the process, we requested all that in an application. We had a hearing before the High Court. The High Court granted each of those requests in one hearing. So we got recognized, we had the authority to sell, trustee ends up selling it, transfers the property back to the United States. It took about 120 days to do it. And if you want a good, compelling reason to adopt the model law, it's because there's a uniform process that you can obtain recognition, you can obtain relief. The whole process can be very beneficial because it saves creditors very substantial money, and there's more money that's able to be dispersed. And it's a very expeditious process. I mean, it works. And not only, Jenny talked about 43 companies or countries that have adopted it. Part of the model law provides that one country can take a look at what another country has ruled in regard to the application of the model and use that as a base. And in fact, UNCITRAL has a system called CLOUT, case law and UNCITRAL text, that details many of those. So you have uniformity, you have predictability, you save costs and expense. And the issue is, if you've got a uniform product that's been well accepted around the world, then why reinvent the wheel? And to answer your question that you started with, would an insolvency professional from India be recognized? My answer is that individual would be recognized, but it would be much more predictable, much more efficient, and if India had adopted the model law as part of the process.
It's also the reverse of it, whether the insolvency proceedings starting elsewhere, be it in US, New Zealand, would they be recognized with the same speed by the Indian courts? And the answer is unfortunately no. We've had very disappointing experiences. Not that orders have not been recognized, but it takes time, and it can be very frustrating at times. In fact, we're currently we're dealing with 3 situations: one out of Hong Kong, one of New Zealand, and one out of Australia, where the debts, they've been insolvent. These individuals have been declared insolvent. Debts range from $5 million to $10 million. We've hired detective agencies. We've identified and located these people in India. They have assets here. They are living a luxurious life. One of them is living in a villa in Goa. The other is somewhere in Hyderabad, Secunderabad, and the other is somewhere in Pune. And we know, but to get these orders declared, to sell their assets here, to be able to recover the money and to send it back to New Zealand, Australia, Hong Kong, as the case may, is going to take at least 2 to 3 years, if not more, or maybe perhaps 5 years. And yet we do not know what will happen because there are taxation issues, what you can repatriate, what you cannot repatriate is going to be immensely difficult. So all this really adds to the frustration. And so it's not just Indian proceedings being recognized outside, it's also about their proceedings being recognized in India.
I'm glad you brought that up. UNCITRAL model law sort of revolves around the concept of COMI, Center of Main Interest. And the proceedings, and some of you may be familiar with this, but the proceedings that have been opened in the jurisdiction where the individual or the entity's COMI is, those proceedings are main proceedings, and those are recognized as such in any enacting state. But while this is such an important term, unfortunately the model law does not define it. So, Ms. Jenny Clift, how would an enacting state look at this? What kind of guidance should it give it in the, let's say, the Act itself? Does it tinker with it? What do we do?
Okay, so when the model law was first enacted, I think the majority of cases focused on Comey, and there was a huge debate amongst judges, practitioners, academics. It was a really productive area. If you wanted to write a paper on something, you could write on Comey. The model law deals with it by simply providing a presumption that in the case of a corporate, it's the place in which the corporation is registered. Being a presumption, of course, it can be rebutted, and that's where the problem, if you like to call it a problem, arises. I think what's happened over the period between 1997 and, say, 2011 was that there was kind of a distillation of jurisprudence. So when first faced with it, courts sort of looked around and started gathering factors together to try to demonstrate that you would have to rely upon to rebut the presumption. So you would be alleging that Comey was somewhere other than the place of registration. And clearly it's particularly relevant in the case of, for example, offshore jurisdictions or those types of situations. But I think what's happened is that now it's kind of been distilled down to a couple of factors. And in 2013, we revised the guide to enactment that accompanies the model law to identify two key factors which are the place, I think, where you conduct your central administration and a place that has to be recognised or recognisable for creditors. To some extent, that builds upon sort of parallel issues of Comey that were taking place also at the same time in the EU. So what the EU's... So we have these two factors, and we say if those two factors are key factors and they should give you a result as to where the Comey is, if for some reason they don't, there's a whole list of other factors that maybe the court can take into account. The EU has gone a step further and come up more with a definition of Comey, but it's essentially based upon what we've done. So I think I'm not seeing so many Comey cases. The courts seem to be able to deal with Comey issues. It's possibly also that the practitioners appearing before the courts also have a better idea of what they're talking about. So they're actually bringing forward the relevant evidence. So I think there's a dual approach, if you like, of providing the clarity perhaps in your legislation, but you don't want to get something that's too narrow. You do want to give the courts, I think, some discretion, but at the same time, practitioners need to be educated. One additional tool we have is that we wrote a document called the Judicial Perspective on the Model on Cross-Border Insolvency, which was written by a High Court judge in New Zealand, the first edition, and that takes the judge through the various steps and the things that you would have to do when you're looking at an application, and it quotes relevant jurisprudence from other jurisdictions. So we do see courts looking at what's happened in other jurisdictions. They'll often say, obviously I'm not bound by what's happening over there, but I'm looking at what the other courts are doing. So I think there's quite a lot of information that would assist courts in dealing with this issue of Comey.
So, Mr. Batra, if we can try to Indianize this situation. UNCITRAL model law sort of contemplates a Comey-based jurisdiction for courts. Now, our IBC is purely registered office-based. Now, do we need a change in the IBC? How do we deal with this?
You make a very valid point, and I think in our initial discussions with the government, of course, they are very preliminary discussions. There was a point of view as to whether it should be left at the discretion of the court, or should we just sort of mention it in this statute, and should it be then the registered office, or should be what the guidance coming out of the UNCITRAL model law is. My sense is, although of course it's too early to say, that we will go by what the UNCITRAL model law says, and will be guided by that. And I think that is what at least our effort would be to persuade the policymakers. At the end of the day, the choice will be theirs. And there's enough experience, as Jenny mentioned, where the courts have, have been, they haven't really struggled, not in the recent years. I haven't really seen any really conflicting judgments coming out of it. And the most recent case, I'm forgetting the name, was where the US recognized that the central main interest was in Canada with regard to very large insolvency. So one will have to be guided by the international jurisprudence on this and leave it to the NCLT to determine on a case-to-case basis, of course, based on the guidelines that are already in the UNCITRAL and the international experience. But restricting it to the registered office would be challenging.
Just one additional point to note is that in something like 90%, if not more, maybe 95% of applications under the model law are not contentious. And so COMI isn't an issue in the vast majority of cases. It's only where you get maybe an offshore jurisdiction or something like that where there is an issue. But the other thing to, I think, note is, without getting too technical, is that in terms of relief, you can end up in the same position irrespective of whether the foreign proceeding is from a main jurisdiction or a non-main jurisdiction. So I think it's dangerous to overemphasise the whole issue of COMI and how problematic it may or may not be.
So one of the situations that I could directly think of is when there is a shifting of COMI. How do you, if in past 10 years, if the company has shifted its head office 3 times, how do you deal with it? So
shifting a COMI, it's either what's called good or bad. So there's two different directions. One direction is where a company has been headquartered in a jurisdiction for many years, such as Germany or Italy, that have very strong labor laws and labor priorities in a bankruptcy. If those companies have the ability to make those payments, but decide to move to the United Kingdom in order to avoid the payment of those obligations, because the UK has a very limited priority period for payment of wages, then that can be a bad COMI shift. It's adversely affecting creditors, where the debtor has ability to make payments, is just trying to take an advantage of the situation. Let's take the other side. Let's talk about situations where COMI shifting can be good. There's a recent case called Ocean Rigs that the company was headquartered in the Marshall Islands, had approximately $4 billion of debt. And when the price of oil went down and business really slowed up, the company got into severe financial problems. And so they were going to have to effectuate a restructure. Well, the Marshall Islands is very limited on what you can do. There's many jurisdictions around the world that you can't restructure. If you file insolvency, you have to liquidate. And so what the company did is they moved their headquarters to the Cayman Islands, because the Cayman Islands has a restructuring scheme much like the UK does, in which you can restructure your debt if you can get the consent of 75% of your creditors. And the company needed to reduce its overall debt from $4 billion to $400 billion. So creditors are taking a massive haircut as part of the process. But the issue that creditors look at in these situations is it better to take the haircut and have the company continue operating so we still have some ongoing business, or is it better to have it liquidated, in which we may get nothing? And so in the Cayman case, in the case of Ocean Rigs, 75% of the creditors approved that restructuring. And so the company was actually restructured, even though the COMI was shifted, but it was beneficial to creditors. And in that case, there was a lot of communication, transparency between the debtor and the creditors, going over and explaining the situation very clearly and asking, explaining what the problems were. And because of that, then the creditors supported the process. And I just want to add one additional issue. The reason COMI is important is that if you have a situation where you have a company that is operating in 5 jurisdictions, then the COMI jurisdiction, which is the based upon the criteria Jenny just went over, is the principal place where the insolvency proceedings will take place, and it's the law in that jurisdiction of how distributions will be made. And so, all the other jurisdictions are ancillary. And so actually what happens is, as assets are liquidated in the other jurisdictions, the funds are transferred to the COMI jurisdiction in order to make disbursements. And so that's why COMI can be very important as part of the process. And, creditors look at that carefully. But as Jenny said, very few contests occur. I think, in fact, the United States, we've had over 2,000 Chapter 15s filed, and the non-objection rate is around 95%. And so that again shows how effective the model law can be in the use of it as part of helping effectuate cross-border insolvency resolution.
Jim, but I certainly see a merit in maybe doing a paper on this for the benefit of the government as and when. I think maybe UI, maybe eventually you've been involved as well. We should probably think of, as CP, do a paper on this, where we could defer to probably some of the recent judgments that come out, and that would probably help the government take a decision at the right time, because they would at least have some guidance on that. And
just to shift gears a little bit, one of the things, Ms. Jenny Cliff, the UNCITRAL has been talking about, and the European Union beat you to it, is that insolvency of group companies. Why is it important, and what is UNCITRAL doing about it?
Sorry, just to correct one very important point, and that is that the EU did not beat UNCITRAL to it. And it didn't beat UNCITRAL to it by probably something like 5 years. So when we did the legislative guide on insolvency law, which some of you may or may not be familiar with, we did a very brief introduction on enterprise groups, and we noted that this was something that we needed to come back and look at more carefully, which we subsequently did, and we added a chapter, part 3 to the legislative guide looking at enterprise groups. And it looked at it both from a domestic point of view and from a cross-border point of view. And the reason we need to look at it in a cross-border context, in addition to the model law, is that the model law only applies to individual debtors. So it applies to a single company that has assets in multiple jurisdictions. What it doesn't do is look at an enterprise group and look at or provide for cooperation and coordination between different debtors where they're members of the same enterprise group. So you can use the model law in the context of an enterprise group, but you have to treat each enterprise group member separately. And there have been some leading cases, particularly in the United Kingdom, where the courts found that the COMI of each and every relevant group member was located in the United Kingdom, and then they were then able to coordinate all of those proceedings through one court. And that's possibly, it's obviously possible in some cases, but it's perhaps not the rule. So what we decided was that we needed to look at, particularly at the cross-border aspects of enterprise groups, and try to come up with a framework for centralising, as far as possible, insolvency proceedings concerning enterprise group members, and at the same time minimise the number of secondary proceedings that might need to be commenced for group members. So it's kind of complex, and I'm not sure you want me to go into it.
Just in terms of why it is important, and I'll ask Mr. Batra to Indianize the problem.
Okay, so I think that the key reason why it's important is that some enormous percentage of business is actually done through enterprise groups. I think if you look at sort of corporate structures, there's very few businesses that just have one company that does everything through that one company, and it doesn't really matter whether you're talking about, sort of a medium to slightly larger enterprise, or you're talking about a multinational. lots and lots of businesses are done through these group structures, and therefore I think it's an economic reality that we need to try and find some kind of framework. It's not just the Lehman Brothers or the shipping companies or the other very large multinationals that we've all heard about.
I'm going to ask you a question. If a company has its call center here, can that be part of the group?
I guess it could be a local subsidiary. The call centre could be, I mean, it depends on the structure
Many,
of the call
many
centre.
of the big US companies and a lot of other companies as well have their call centers, service centers here.
Could be.
Sorry, Mr. Bhatta, you would want to?
Well, I think after the cross-border insolvency law, this is probably one of the most critical issues that we face. And again, similar to the cross-border issues in these big 12 cases, nearly all these big cases have group of companies issues. So you have a company, which could be a holding company or probably could be a group company, which let's say produces steel or let's say produces auto components, but it has another subsidiary or a sister company from which which does craft, whatever you may say, in terms of producing one component. There's another company which does another kind of treatment to those auto components that you may be doing. And there is a third company which is basically the sales and marketing company. At the end of the day, the whole business is a composite business. There are common employees, there's a common management, the shareholding there's so much of crossover shareholding. The lenders have common interest, the assets are secured, in a crossway with the lenders. It is so deeply integrated that it is absolutely impossible to separate them. And if you do insolvency of one company without really taking and dealing with the other assets, it's impossible to achieve an efficient and effective insolvency. So now the challenge is that here in the Indian context, as we were just discussing, the insolvency has to be commenced before the NCLT, where the registered office of the company is. Now, just imagine you have 8 companies in a group, and all of them need to go to insolvency, and it is possible that all these 8 would be in different jurisdictions in terms of where the registered office could be. And I know a live case where in one of the companies which is in insolvency, where the lenders have decided to take the 3 subsidiaries into insolvency, and all these 3 different subsidiaries are in different states with different registered office. So now you will have 4 different NCLTs supervising these. And there is a possibility that you may have 4 different insolvency professionals appointed as resolution professionals who would be obviously competing with one another to protect their turf, their interest, and you would end up compromising the efficiency of all the 4. So it is inevitable that you would have to have a mechanism, a system by which you will have to provide a platform, a mechanism by which group of companies can be combined, or at least even if they're not being combined and they are following one another successively, you have to make sure that they go before one NCLT, and there's one common insolvency professional who's appointed resolution professional, and that the conflict of interest issue is then looked at from a slightly different prism, because otherwise you would end up dealing with the conflict of interest issues also, because you are selling the assets of the subsidiary, which is a separate legal entity on its own and is entitled to preserve its own assets for its own value and to return it to its own individual stakeholders. Then how do you deal with the conflict of interest issues? So that is also a very important aspect. So I think it's a very burning issue. We have brought it to the notice of the government already, and I think government has taken cognizance of it, and hopefully we'll get it addressed also in a very short soon.
The work on group enterprises has been the most difficult, complex issue that UNCITRAL has ever addressed. And just so that you understand the complexity, we have common law, we have civil law countries. UNCITRAL, Working Group 5, when an agreement is reached, we do that by consensus. That means people have to agree. And think of countries around the world agreeing on one structure. And there's extensive debate. I mean, we've debated this process probably 5-6 years before we got to the point that people recognize you can actually do something with the process. And so what happens is the work that comes out is extremely balanced. You have all different interests that are taken into consideration, are addressed, and when you reach consensus, and we have on the primary aspects of this, the U.S. strongly supports this. you'll have an excellent product that's been vetted, and with it, as both Sumant and Jenny have said, this is one of the most important projects that can be developed, because most of your major cross-border issues now are group enterprise. So, thank you.
I'm going to go back to Dr. Garg now. How does it help the business sentiment? How does it help doing business in a country which has moral law or which has a good cross-border insolvency regime?
Right. So I will refer to not just the cross-border insolvency law. Here, what is required is the insolvency law. So traditionally, the word bankruptcy has been associated with some sort of a stigma, and there is a psychological pressure upon the debtors, the borrowers, and somehow the system should be there which favors resolution. So the term and the discussion that my view is based upon a robust insolvency law. And when we work for a robust insolvency law, we work for the entire gamut of the laws, the legal system and institutions surrounding it. A robust system of cross-border insolvency is a part and parcel. Now, to develop a robust system of insolvency legislation and institutions and practice, because this is commercial law. Commercial law is based upon usages and practices. Okay? So it is not law, it is first usage practice, and it is adopted into a law or it is adopted into a code. So here we have the IBC, which has been adopted into a code, which is basically based upon the principles and usages and practices. Now, it involves the commercial law, contract, banking law, corporate law, the entire plethora of commercial laws which are required to be updated and streamlined. So when we have a robust system of such insolvency law, it creates a tremendous confidence in the people. And the question is in relation to the business sentiment. Now, business sentiment, or in other words, the ease of doing business, what does the business want? Business want predictability. Right through the first session, people, the professionals, practitioners are interested in certain issues, certain questions, what can be a predictable solution or answer to which they can suggest to their clients. The client comes to you with a problem, you need to suggest a solution, you need to suggest a relief, and you want the predictability. Everybody wants the predictability. Predictability will come when the system has a robust mechanism. So to develop the business sentiment, the predictability quotient is required. Predictability will be there when there will be either in the form of a code or in the form of a universally accepted principles, the legislation and the practices are evolved. So the relation of cross-border insolvency is, as I mentioned in my earlier observation, we are and we have been referring to some foreign laws. Now, there is a sort of a not allergy, but there is a difficult concept whether you want to adopt a foreign law or whether you want to adopt international law. So one difference has to be carefully understood. We are not and we should not be allergic to international law, but we may have issues with a foreign law, and we have to understand this difference. International law we are making, we had a Constituent Assembly simple example. So we are part and parcel of the international law. So international law we are adopting. This means we are adopting transplanting a culture which has been created through the discussion of various participants of developing and even underdeveloping countries. So a lot of peoples, lot of parties, lot of states concerns have been considered in drafting of that international law. That international law might be in the form of a model law, or it might be in the form of a treaty, or it might be in the form of a principles or a legislative guide. So the approach of the people should be that yes, we are not adopting a foreign law of US or UK or Singapore, but we are, and we should be enthusiastic, or we should be positive in looking towards the best practices or in international law and how we can reform our law. So business sentiment, if our law has not changed, if our law has not evolved, if our law has not reformed, every law needs reform and updation. If it has not, then you have to refer to something. What will you refer? Either you create your own, or you refer to international law or international best practices. So to create the business sentiment, we need the reform in law, and looking towards a well-established and coherent international law or model law is a good example.
All right. Before we open the floor for questions, Mr. Batra talked about a bill that has already been sort of submitted to the MCA. Would you like to quickly talk about that?
Well, I think it may not be fair to talk about the principles or the features of the model bill, because I think it's still not out in the public domain. So one would want to discuss the specific provisions. Suffice to say that it's primarily based on the unsettled model law. It doesn't make any key deviations. The only thing which probably we thought might be appropriate is to sort of define what public policy is, because what the exception to the leave with the unsettled model law provides is the public policy exception, and public policy exception, to make it a little bit more clear and concise, one has attempted to define it, but that was the sentiment of the group that worked on the draft bill. But at the end of the day, it will be the government which would decide it and leave it perhaps to the judiciary, because it has been well articulated in a number of judgments by the Supreme Court and other courts in terms of what the public policy means, and in particular when you're using it as an exception. I think the only challenge that we might face is that, and that probably is the one single challenge that I'm concerned about, is that in the Insolvency and Bankruptcy Code, we do not have a provision for interim relief. There's no specific provision for grant of interim relief till such time the petition is not admitted. While the unsettled model law provides for a relief to be granted between the period when your application is presented and is recognized, and to that extent there might be a contradiction in the two, and that the legislature may see as something unacceptable, because if that is not in the national legislation, then should it be provided in the model law, which would then benefit one set of consumers and not the other. And that, in fact, in my opinion, actually makes out a case for providing a similar provision in the IBC, because there should really be a provision, and in fact that is a lacuna in my opinion, although it will happen by way of jurisprudence, because the court will invariably in some case say that till such time the petition is also admitted, the courts have the power to grant interim relief to protect the interest of the stakeholders or the assets, because the courts can't shut their eyes to something and say helpless, that they're helpless in such situations. So that probably is the only critical part of it, if I may say. Otherwise, by and large, it is actually articulated the way the unsettled model law expects.
We can take questions for the floor. I know it's the last session, but we can still ask some questions. Yes, Divyanshu, 1, 2, yeah.
So, you talk about group insolvency.
Anybody in particular, or anybody?
Christopher, if you could answer this question, right? So we talked about group insolvencies and it's being the most complex one, and significant efforts have been made in terms of putting together some form of a code or law around it. And given in India, legislation usually takes a long time, but any one or two key areas which you could identify, which in a situation like a group insolvency where different, what Sumant was talking about, different IP, different jurisdictions, where the parties could come together to ensure that it's more of an efficient process?
One of the primary elements in group enterprises is often that you have common administration, you may have a common accounting, you may have common employees. You'll also have IP that may be shared with the entire group. And often you'll have financing throughout the entire group with a number of financial institutions, usually on a group basis. And so it's important to be able, if that entity can restructure, and sometimes group enterprises have a number of members that are no longer operating successfully, and they may need to be shed. And so the group itself wants to be able to restructure. And if you have a uniform law that helps you and provides for that, and lenders. I mean, one of the key in group enterprises is banks have to be comfortable. They have to know that the security interest they had still is in place. They have to know there's still viability, that their loans are being recognized as part of the process. And group enterprise can help effectuate that. And one of the really important issues is one of the most difficult issues in the United States for companies, especially groups, to reorganize is the cost. And so part of the key is if you can have an effective procedure that helps expedite that process, reduce the cost, you'll have a much better chance of that entity surviving and being able to actually restructure as part of the process. So the utilization of a group enterprise law would help effectuate that, because look around the world. I mean, this issue's been recognized as a major problem for 20 years, and nobody has addressed this issue. And so this group enterprise structure is one that I believe is acceptable to the states around the world. I'm the U.S. delegate, so I've been heavily involved in this, and I've seen other states, and there is consensus on this product.
Can I just add, what we're doing is in this project is two things. We're looking at the provisions you would need in your domestic law. So Sumant's problem of the group with entities in different states in India is covered, plus the cross-border element. So it does both things.
But like in the past, has there been any contractual arrangements which have been attempted while the law has not been there, and whether those contractual arrangements have been effective?
There have been protocols that have been used for this purpose among different insolvency practitioners to run the process in a coordinated and efficient manner. As in just now, I'm not sure if even EU has the provisions. That's the only one where we have it, but I'm not sure if that has been sort of used yet properly. It just became operational. Sorry, there was a question there. Yeah, go ahead.
So my question is that it essential that both the countries, number one, the country where the insolvency proceeding has initiated, and number two, the country where the offshore assets are located, is it essential that both the countries should have the same model law or some equitable law in order for the proceeds from the company, from the country of the offshore assets to flow to the other country?
Although there's 43 states have adopted the model law, there's a number of other jurisdictions, like the Cayman Islands, because of COMI, that won't adopt it. But if you look at the decisional case law they utilize, it's all based exactly on the model law. Isle of Man does the same thing. We recently were involved in a case in Antigua, a $10 billion pyramid Ponzi scheme. And the court, Antigua, has not adopted the model law, but when the insolvency representative was appointed, the procedure that the court ordered that individual to follow was directly out of the model law. So more and more jurisdictions are recognizing that as part of the process. So there's a lot more uniformity as part of the process. And I think that one of the main issues is if you go to a country or a state that doesn't have the model law, you may not get the same benefits that we were able to get in the UK with one hearing. You may have to go through a number of different hearings, which obviously makes the process more expensive.
So in that case, there might be some companies which are incorporated from the very beginning with an underlying objective of committing a fraud on a later date. So if, for example, we bring in the model law on the cross-border insolvency in India, there might be such companies which I'm talking about who will be smart enough to do some research and place their assets in the countries which do not have such equitable laws. So what is the solution in such cases?
Well, one of my areas of practice is tracing assets into foreign jurisdictions and recovering those. I've been doing this for 35 years. And so there's established laws in those jurisdictions that specifically address those kind of issues separately and apart from the insolvency code. The key element is having the insolvency professional, the trustee, recognized in the jurisdiction so that individual has standing to bring those different actions to effectuate recovery.
So at last, it all boils down to recognition of the laws by all the countries. So we have to move towards an environment of law where each and every country recognizes such laws. Only then the problem can be solved.
I hope you are not participating in the moot tomorrow. So, are there any other questions? Yeah.
My question is regarding COMI. Now, many scholars believe that COMI is one of the factors that can be considered to determine a COMI is where a crown jewel of that company is situated. So a lot of time what happens is the parent company establishes a company in Singapore whose only business is to channelize funds to India, where the main asset is situated. In this situation, isn't it an ideal way to put it across that COMI should be the main asset of the company instead of where they're recognized or where the registered office of the company is situated?
Well, it'll depend. If Singapore is where the entire financial activity is taking place, and that is where the main lenders are, and that's where the actual restructuring should take place, then Singapore would be the center of main interest. Then it's immaterial where the center, where the asset might located be. So supposedly, you may have the holding company in Singapore, which is manufacturing, let's say, auto cars in Chennai. So while the unit may be in Chennai, the physical assets may be in Chennai, but all the lenders may be sitting in London, or in Singapore, or in New York. And actually, if at all the restructuring has to take place, it'll take place offshore, right? It need not necessarily take place in Chennai. So therefore, in that particular case, the courts would decide that the center of main interest is in Singapore, right? So in today's world, and that is why we earlier raised this point of how the COMI is a very dynamic thing. It's mobile. And so today, the main set of lenders may be in Singapore. Tomorrow, the holding company may be acquired by another entity, a super holding company, which may be located in London. So therefore, the center of main interest might move to London a year down the line. So that is exactly the point. It will depend on a case-to-case basis.
So it's interesting. Actually, there's too much focus upon COMI. Maybe we can also have some aspects like what is the main proceeding. Let's take an example like assuming a country makes a rule that the main proceeding will be recognized when the insolvency petition is filed. Another country might make a rule that main proceeding will be recognized when the insolvency petition is admitted. Okay, so there is a same debtor, okay, and the creditor might file a petition in a country which recognizes that when the insolvency petition is admitted and the debtor goes on to file in a country which is suitable for him, on which the date of filing of petition is recognized as the main proceeding. So what happens is then the country which recognizes the date of filing as a main proceeding, they will recognize, okay, this is the main proceeding, and the others will be the non-main proceeding or the secondary proceeding. So there are a lot of aspects, and I'm not sure that whether it's only the COMI which decides or a lot of factors, and that's why the country, a particular state, has to be very careful in identifying these issues.
In any case, that's the end of our panel. I thank my distinguished panel here for their views, and I thank the audience for their patience. Thank you.
I would like to thank all the speakers for their comments and would request them to please accept the mementos. The tea is placed outside.